And sometimes people are forced into it because of financial circumstances. Other times it's their own choice. That is something that the law has to recognize, that some people do not have attorneys. I think it's much easier for the court to deal with attorneys than it is to deal with people who appear on their own, because the people who appear on their own obviously haven't been to law school. They don't know the rules of criminal procedure. They don't know the rules of evidence. So it makes it more difficult for them to present their case. When a judge sees a situation like that, you have to be patient above all. You can't try the case for them, because that would be improper. That would be overstepping your role as a judge. But you need to be patient. You need to still give them their day in court. They might be the little guy, as I say, or, you know, it's kind of like not the big top dollar lawyer. And maybe they're going against a top dollar lawyer. That doesn't mean that they don't deserve their fair day in court. So above all, be patient with them. You know, help them along as much as you can by pointing them in the right direction as far as resources. Tell them where the law library is. Tell them where there are forms available that they can use. Tell them that there are some legal services out there. Give them some names and numbers of places that might be able to help them. Set them up with the Bar Association has a pro bono attorney referral service. Maybe they can at least get some advice over the phone if they can't get an actual attorney to try their case. I think it's the court's duty as a judge to make sure that they have the resources that are available out there and that they know about them.
Right, yes.
So I think that is important. But in the end, if they do end up appearing on their own, like I said, patience is probably the key to making sure that they get their day in court. It might take a little longer. You might have other things that you need to get moving on as well. But everybody deserves their own day in court. It's the people's court. That's what we're here for.
And I think that, you know, this idea that you've expressed, that, you know, people are entitled to their day in court if they choose that that's what they want to do, and they're not able to come to some kind of a mediated settlement or whatever the issue may be. And yet sometimes I do see, as a practicing attorney, that occasionally folks who are there in court who don't have an attorney, that it seems like there's more pressure put upon them to just come to a settlement so you won't have to go to trial. How are you going to represent yourself at trial? I have heard that asked of pro se litigants so many times when I'm just sitting in court waiting my turn, you know, asking them, well, how are you going to appear and represent yourself in court? Well, that doesn't help to create a very welcoming atmosphere to say that, you know, you do deserve your day in court if you want to pursue it.
Right.
Yeah.
Like I said, it does present a challenge to a judge because it does take a little more time.
Yes.
And it takes a lot of effort and it takes a lot of patience, you know, to make sure that those persons who choose to represent themselves, that their rights are being protected. But like I said, we might have to take that a little extra time to say, you know, Mr. So-and-so, you are here for a pretrial hearing. At a pretrial hearing, this is what's expected. These are the issues we'll need to talk about today and resolve, you know, and we're going to go through them one by one. And just to make sure, above all, if they need more time, you know.
Right.
Sometimes you see it's like, well, I don't have the money right now, but if you give me just a couple more weeks, I might be able to get somebody to help me. Give them that time, you know.
And I think for some folks, you know, there's the uncertainty makes them nervous. And so if they have some kind of a structure and a framework that they know that is expected or what it's going to be, then that makes them more able to proceed in a way where they can represent themselves if that's what they're going to be doing. And I think the help, you know, self-help fact sheets and those kinds of things which lay down what the procedures actually are, and, you know, what is the difference between, you know, a motion to reconsider or whatever, you know, and whether or not it's something else. And maybe that, you know, there's another step before you do a motion to reconsider, because I'll tell you, that's probably one of the things that I hear most common, actually from people that I have talked to who are pro se litigants. If they didn't like the result of what they got, they go, I'm just going to do a motion to reconsider. And I'm like, well, it's not as easy as that, but they think it is.
It's
but they
not.
but they don't realize that. I mean, it sounds good, common sense, but that's not quite how it works. You know?
Exactly.
See, so I mean, that's one of those kind of things. Now, it sounds like maybe we had a caller on the line. Okay, caller, thank you for calling in. Questions or comments?
Mayor Longery, good show again tonight. Hey, this person, this Iverson running, seems very remarkable because I look in the paper and it seems like all the judiciary and politics is full of either, when it comes to attorneys, prosecutors, or insurance company lawyers defending the big guys like Wellstone would say the Rockefellers and not the little feller. It's good to see there's somebody here. You know, I'm looking at this election for governor. Emmer, he's an insurance company lawyer. Leary was an ex-insurance company lawyer. You got Klobuchar, who's an ex-prosecutor. You know, always, even if these guys decide in midlife that they would like to help the little feller out, I don't think they know how to, because they've been defending the big guys, the big corporate structure so long. So, you know, I'm voting for you. You're a refreshing change. We need more of you and less of these other guys and these political hacks that so often make it to the bench. Thanks for running.
Thank you. I appreciate that.
Well, thank you, caller, for that call. And, well, you know, and the caller brings up some good issues, is that, you know, again, you know, it seems like there often is a field full of, you know, prosecutors, big-time attorneys who decide that they want to be judges. And does that have an impact on our judiciary system?
Well, you know, to be honest with you, we're actually quite lucky in Ramsey County. There are a number of judges on the bench who actually came out of the public defender's office.
Oh, that's good.
Yes. Most recently, Judge Alshouse came out of our office. Judge Clary, Judge Mott, Judge Johnson, Judge DeCourcy.
So you
I might be missing a few even.
And so you'd be joining a fine group of folks who had the similar background, and I think that's a good idea. The other day I was when I was in court, there was something that I saw that really brought to my mind how important it is to have a judge who is listening to what is going on before them. Because I was in a pretrial, criminal pretrial, and the case before mine, that was a plea agreement. And the judge was inquiring of the individual about their decision to take this plea agreement and whether or not if it was really the right thing to do. And you could see halfway through this individual describing or trying to talk or whatever about how they wanted to take this plea agreement, that it was not so much that because they thought that, yes, they were guilty, they had done this, but because it was, well, the best thing to do for all the family members involved. And it's kind of a sad thing, because here she is trying to explain what's going on, but the judge said, you know what, I think what we need to do here is that we need to you know, set this case aside, and we can come back to it a little later today, this morning, so you have time to talk to your attorney, so that you could take the time you need to decide if you really should do this or if you should go to trial. And I thought, you know, that was a really good thing. I really felt the judge did a very good thing, because oftentimes I don't see that happening necessarily, and I don't mean just in Ramsey County, but in other counties too. It's just that because there is this time pressure to get people through, we need to get the cases done, and we got to push them through, because we've only got 20 more this morning, and come on, move along. And sometimes it takes a little bit more time to have deliberation.
That's true. And you know, A lot of our judges do a pretty good job of you know, making sure that the defendant is making a choice that they've thought about. Is this a voluntary choice? Have you had enough time? A lot of them will ask, have you had enough time to talk to your lawyer? Are you sure this is what you want to do? Now, if you look just at the rules of criminal procedure themselves, under Rule 15, which allows for the plea of guilty, the judge is supposed to make an inquiry about whether or not they understand their rights and that they understand that they're giving up their trial. And all of those rights associated with it. There aren't going to be any witnesses. You're not going to be able to testify. You're giving up your defenses, self-defense, intoxication, all of those. You can't claim those anymore. You're giving up your right to challenge any like legal issues like search and seizure. And so there's a lot that goes along with other than I'm just pleading guilty.
Right.
You're giving up all of those rights. We have a very extensive plea petition that you need to go through. And when you get to the bottom of it, probably the most problematic for people like the individual you were just talking about, when you get to the line that says, a judge will not accept a plea of guilty for anyone who claims to be innocent. I now make no claim that I am innocent. That gives a lot of people pause. It makes them kind of think. Because you hear some people, well, I just don't want to spend the time going through trial.
Right.
I think I'll lose anyway. You know, everything's against me. I don't want to put a family member through a difficult ordeal.
Right.
I am afraid that if I go to trial, I'll get convicted of something more serious. I might go to prison versus getting probation. Those are all sorts of things that run through someone's head. If I plead guilty today, I can be released pending sentencing. I could get out of custody today. That is a huge allure to somebody who's charged with a crime. So even though all of those things might come into play, in the end, you have to plead guilty because you believe you are guilty.
Right, exactly.
So, and when a judge takes the time to make sure that that is in fact the ultimate choice, you might have all these other deciding factors, but the judge has a duty to make sure that this is what they want to do, because once it's done, it's very difficult to undo.
Exactly. And I think that was indeed the turning point for this individual when the judge had that feeling that maybe this person actually couldn't say yes, that yes, they're guilty, and that they do not claim to be innocent. And then the further inquiry certainly showed that that this individual needed more time. Now, I understand we have another caller on the line.
Okay.
Caller, thank you for calling in. How can we help you today?
Yeah, I have a question.
Yes?
How many judges make bad decisions, maybe on bad information, or just because they know someone that doesn't want it to go that way? And I'm not knocking Connie because she seems like a very nice person, you know. But it's weird. There's a lot of people that have been buried for no reason.
Well, you know, the caller brings up a concern I think a lot of citizens have out there, is that, you know, you go to court, you're presenting your case in front of the judge or the jury, and, you know, your life basically is in their hands. And, you know, how do you know, you can only hope that they'll be able to see, you know, what the reality is. You know, so I don't know if there's really any statistics about the number of bad decisions, but, you know, on the other hand, when cases do go to appeals court, how many cases are sent back to the lower, back to district court again?
Not a lot. Not a lot. It's difficult to win an appeal. I'm not saying it doesn't ever happen. We get a fair number of cases that get, we called it remanded, back to the district court level for a new trial, sometimes for just specific things, findings of fact, sometimes for resentencing. Maybe the sentence was wrong. They didn't apply the law correctly in the sentencing. So, you know, to actually get a case just simply reversed outright and it gets dismissed, that's very rare.
Right.
Very rare.
Right, because the thing is, I think a lot of times people don't realize is that if your case does go to appeals court, it doesn't mean that you get to retry the case all over again, bring in new facts or other new stuff or whatever. That's not what happens at all. That they really can only look at what was the testimony, what were the exhibits, what is the law, was it applied correctly, and there's certain standards that have to be met. But I think sometimes part of this idea about, you know, having realistic expectations about your